Welcome, Darren.
Thanks for having me.
Well, I think a lot of people know who you are because you're awful prolific writing these days on your weekly newsletter. But why don't you tell everybody a little bit about what Heitner Legal is and also your path to getting to where you are today?
I'm happy to do so. I started my firm, Heitner Legal, back in June 2014. So I'm coming up on 10 years. And prior to starting my own firm, I had practiced at two other firms in South Florida, one in Fort Lauderdale and one in Miami. The Fort Lauderdale one was straight out of law school, got my feet wet doing insurance defense litigation of all things. But on the side, when I had time, I was busy building up my book of business in areas that I was interested in. Initially, intellectual property, copyright, trademark matters, which I still do today. And then when I could, I would dabble in the world of sports. And ultimately, when I pivoted 1 year into practicing and went down to Miami, I worked with an individual who was known as an entertainment lawyer for a long time, but also was interested in building up a sports practice and gave me a lot of liberty to grow my book of business in that space. Concurrently, I was shifting away from being a sports agent, which I had started my own sports agency in 2007, actually my 1L year at University of Florida, built it up over those 3 years. And at the first firm, it wasn't a large firm. They let me continue to do that on the side. When I pivoted out of that, instead of burning bridges and ruining relationships with competitors at the time, I tried to be on friendly terms with them. And when I exited the sports agency world, I attempted to convert those former competitors into clients and was able to effectively do so. One thing that helped me out a lot was I had started a website back in 2005 called Sports Agent Blog, which had covered the sports agent industry. It's much less active today, but used to be extremely active, promoting, publishing content on a daily basis. And so that helped me establish somewhat of a name in the industry and at least allowed individuals that I was then talking to recognize me and give me a shot. And the rest is history.
Well, that's a couple interesting points that I just want to focus on, especially for any law students tuning in. You talked about, first of all, that you just started out in what one might guess is not your ideal job, doing insurance defense litigation. But as I've always said, a background in any kind of litigation is a great training ground for becoming a transactional lawyer, because you get involved in situations where you see how things might not have turned out so poorly had somebody had better drafting skills, for example. And then the other thing that you mentioned, which we talk a lot about on this program, and I think is critically important, is the concept of relationships. And you pointed out, you didn't want to burn relationships, but I'd like you to just sort of a couple of sentences, a couple of thoughts on something you said that really struck me, was how you can take not necessarily clients, but you can take adversaries or people on the other side of a transaction and turn them into clients based on relationships, which I think people think it's black and white. It's so gray. I think it's an important point to discuss.
It is. It's really interesting. And I've had this experience on multiple occasions throughout my 13-year career as a lawyer, where individuals or corporate entities on the other side, either of a transaction or even litigation, would come to me at the conclusion and say, as long as there's not a conflict, would you be interested in working with me further? And I'll take it a step further than that. It's not only individuals or corporate entities on the other side of a transaction or litigation, it's even lawyers on the other side. I think oftentimes we as lawyers forget that not only is there a code of ethics that we need to abide by and hold ourselves up to, but we should be cordial with our adversaries. In litigation, we want ultimately what's the best for our clients. And I think far too often in emails and phone calls, and terribly sometimes even in front of judges, we don't familiarize ourselves with that, or we forget what our mission is. and we just start attacking the other side. I mean, I'll mention a name who I have gone up against on multiple occasions in the world of sport. Greg Clifton. He's been practicing for a very long time in this space. Wonderful individual. And we will go head to head when we have clients on opposing sides. But I've sent him a bunch of business. He sent me a bunch of business. I believe he's part of the Sports Lawyers Association as well.
Yes.
And that's irrespective of the fact that sometimes we find ourselves on the opposite side of a dispute. And so I think it's super important. You can earn and build the respect of your adversaries. Definitely take your job seriously, but understand what your job is. And it's not necessarily to get under the skin of opposing counsel.
Yeah, I think representation of your client is really important on a lot of levels, just because how you portray yourself to the other side. Now, the press, and we've got a lot of bad publicity about lawyers because there are some lawyers who don't understand what zealous representation means, and we won't use the word, but they're not friendly characters, and they give the rest of us a bad name. But I have found that if you just are straightforward, show that you're knowledgeable in an area, that oftentimes, I mean, I've gotten clients that way. I represented a company, and on the other side was this other business. And when we were done, the president of the company called me and said, "Are you exclusive? Could you work for us?" And I go, "Yeah, there's no conflict." And that happens. Or by the same token, many years ago when I was a litigator, I once got a call and this guy said, "Hi, I don't know if you remember me, but we were on this litigation." And I go, "Oh yeah, no, I remember that case." And he goes, "This is kind of, my client wants to pursue it. It's a dog, but somehow you convinced a judge to let a case go forward. So would you mind giving this one a shot?" And I said, "Sure." But that's because I wasn't being a jerk and I was easy to work with. And, you're arguing on different sides. It's, you got that third person disinterested thing is really important. And it doesn't take away from representing your clients. But those are some 30,000 foot views. Let's drop down our plane a little bit. And I want to talk to you about your favorite subject because you write so goddamn much about it. But my first topic I want to talk about is obviously name, image, and likeness rights of collegiate athletes. There's a million things to talk about, but clearly we're in a situation where we have multiple state laws. I don't know what it's up to. I guess we're nearing 30 states with legislation now, something in that ballpark. And then we've had a couple of senators talking about national legislation. You have the FAIR Act, which seems to be more designed to create a barrier to the college athletes making money as a incentive, I think. So I don't know where any of these proposals are now, but you see them keep coming out because we have so much talk about, well, you need national legislation. And since Alston, which is not an NIL case, I keep saying, since Alston said that NC2A, there's no antitrust exemption, it sort of opened up the world on July 1st, 2021. So I guess my big ticket question for you is, do you think we need national legislation? I mean, it might make it easier for people in the space to go, "Oh, wait a second. No, this client's in Iowa. Does Iowa have legislation? No, it doesn't. So who do I go to?" I mean,
I can't believe you used Iowa as an example because I actually had a conversation with a major brand client today about Iowa. So I actually know a little bit about Iowa. And I won't mention the brand name nor the athlete that we were discussing, but in the diligence, when we were going through a contract that we intend to provide to the athlete, one of the things that we had to do was look up to see if Iowa is one of those 30 or so states with an NIL law. And in fact, Iowa happened to propose legislation in the past, but never ended up passing any bill and putting it in front of the governor for signature. So that leaves any individual in the state having to look at his or her school's NIL policy and then, of course, the NCAA rules. One thing I will mention, you can scream as loud as you can that Alston had nothing to do with NIL and journalists still won't listen to you. But I appreciate you pointing that out. For some reason, no one seems to understand that. I do love that one line from Justice Kavanaugh in his
Oh
concurring opinion
God.
that the NCAA is not above the law. I was actually writing for Above the Law at the time, so I found that to be pretty funny. Um, to your question, is there a need for federal legislation or, in fact, a federal law? The answer is absolutely not. There is not a need. If we look to what we're talking about with NIL, name, image, and likeness, we're really talking about an individual's capacity to monetize his or her right of publicity and also to take action against a third party that might use that person's right of publicity without that person's consent when it's done in a commercial manner for an
Thank
advertisement.
you, Ed. Thank you, Ed O'Bannon.
Exactly. Thank you, Ed O'Bannon. But this concept of a right of publicity goes back about a century. New York, I believe, the first state to officially codify it, and it's derived from what we consider to be an individual's right to privacy. But what's been interesting over the past century is that the federal government has been completely hands off when it comes to rights of publicity, or what we in the college space refer to as NIL. Instead, the federal government has allowed states, whether it be by statute, and roughly half the states have statutes on the books related to misappropriation of one's right of publicity, or NIL. The other half of the states have determined through case law developed by the courts that these are rights that are owned by individuals and that these individuals have the right to commercialize their fame, but also have the capacity to go against third parties who use those rights without their permission. Oddly, the NCAA has taken this perverse position over decades that college athletes in particular cannot monetize their fame. But one thing that I think was forgotten as California looked at this issue, as Florida, as Colorado, the first three states to look at this issue, and now, as you mentioned, we're at roughly 30, is that there was such a direct focus on the college athlete that we forgot that the high school athletes also affected by this. Because prior to July 1, 2021, the only state that was allowing high school athletes to monetize their fame was California. A big reason why is you had this cottage industry of individuals at an early age, mainly in the entertainment space, who were able to make money off of their fame, whether it be acting, entertainment, et cetera. What we've seen since now is 31 states in Washington, D.C., through their high school athletic associations, change their rules to allow high school athletes to also monetize their fame, but then we also are left with some states that don't. Back to your question, we don't need the federal government to get involved because the federal government has not gotten involved in rights and publicity for other individuals for the past century. And even though there are differentiations state by statute or based on the case law that's been developed, no one's screaming aloud saying Congress has to get involved in everyone else's rights of publicity. The one area where I would like federal intervention is with respect to international athletes, athletes who are in the United States on F1 visas. The reason being is that I don't think it is fair that we are ostracizing those individuals and making it incredibly hard or frustrating for them to enter into NIL deals. They can always do it, but there's the threat hanging above their heads that there could be repercussions with regard to their visa status. And that's what scares me. And so there is an individual, Chris Murphy, who from Connecticut, senator, who is the only one that I'm aware of. I think it's him and Representative Trahan from Massachusetts who have made reference to this, but everyone else seems to forget it. We've gone through 9 congressional hearings thus far. It's mentioned rarely. Instead, we typically even deviate from NIL and we talk about the health, safety, and welfare for the athletes. And more so, we talked about whether a particular senator or representative came from a school that was successful in sports when they were there. So it's rarely on point. But overall, I do not think that the federal government needs to get involved.
Well, what I think's interesting, obviously, for those that aren't aware of this, and you pointed it out, but if I'm a Serbian basketball player and I'm playing for the #1 ranked team in the country, as of present, I am not allowed to make NIL money because I'm not American. That seems unjust. But we've come a long way because many years ago, many years ago, when I was a undergraduate, my friends who were football or basketball players used to laugh about what they called the $100 handshake, which was, you're not allowed at the time, the rules up until really 2 years ago were if you were a scholarship athlete, you couldn't have a job, and you certainly couldn't, say, hi, I'm Bobby Hacker from XYZ school, come down to Joe's barbershop and get a great cut. I wasn't allowed to do that. And if you consider the fact that less than 0.1% of all collegiate athletes ever move on to make money as a professional athlete. So you've got basically a 4 or 5, or in COVID, a 6-year window during which you can monetize your celebrity. And after that, it's done. It makes sense that you're allowing them to do that. I think one of the problems, and you've been very active in the space, obviously, but it seems to me that one of the big problems has been what are we really talking about when you say they have right to make money on their name, image, and likeness, but we prohibit pay to play. That's not happening. And that seems to me a fairly Pollyanna-ish approach, because when you look at a combination of this new crazy transfer portal rules and the right to make NIL money, and then you layer on top of that the development of collectives, where do we find that line? What is that line between, well, I'm making money on my name, image, and likeness, and I'm not being paid to play? And I realize it's a very slippery slope. And as lawyers, we know how to maneuver around that and work our words. But I think on a big picture, it's changed college sports in a lot of ways, not necessarily just for the benefit of the athletes, but it's changed college athletics generally, especially when we're talking about the big three: football, men's and women's basketball.
Very much so. And when we delve into I guess you could refer to it as the recruiting styled inducements, I oftentimes call that the quote unquote NIL as opposed to the true NIL. And again, I think overall we're sort of being a bit lazy when we use NIL to cover everything. You even talked about the fact that you couldn't make money by creating your own business in the past, but you can now. That's not truly NIL, but we characterize that within the umbrella of NIL, just like we do camps and clinics, which oftentimes isn't necessarily a use of one's NIL. More traditional endorsement style activity, or really lending one's name, image, and likeness for product packaging that the third party is using, or using it in advertisements, is more so NIL. But I respect your position, and I agree when we're talking about boosters or collectives providing capital to athletes when they're going from high school to the next level, or also when we're talking about players now having the right to transfer at least once without sitting out, and money is exchanging hands in that process. I think it's quite clear that this is what the NCAA was most concerned about and what it wanted to curb. It just cannot. As you mentioned, if you're utilizing creative processes and you have good lawyers on each side of the table, I think you can negotiate around it. And we're seeing that happen in real time. I think that's one part of it. The other part is the NCAA just simply, without any sort of subpoena power and without anyone wanting to step up and voluntarily provide information that's going to assist it in enforcing its rules, along with the fact that it just has a very depleted staff of individuals on this, it makes it quite complicated for the NCAA. And so we've seen a plethora of activity in this space. I think initially more so when we're talking about high school athletes being paid considerably in exchange for committing to a university. But now so much attention is being paid to the transfer portal because in essence, what it's created is a form of unrestricted free agency.
Exactly.
If you're an athlete, I mean, I understand the value that could be attached from very quickly and prominently stating your allegiance to the school that you're with, and maybe there's some benefits that are attached with it. One of which obviously is you're not jeopardizing your scholarship if you decide to enter into the transfer portal and you don't find a home. But for the most talented superstars, they can put their name into this transfer portal, and you better believe that there are boosters and collectives around the country, and sometimes even the schools themselves and their staff that are reaching out. And maybe they're not putting a contract in front of those players, but numbers are being mentioned, at least loosely. And so that's one thing that I think is a big issue. But one thing that came up in my mind when you posed the question, you mentioned the words pay for play. And to me, that's a separate bucket within the NCAA's prohibitions that I don't believe is proper. I think athletes should be able to enter into deals with third parties where they get incentivized for their performance. We see it in the professional ranks. An athlete can enter into a contract with a brand that says the athlete gets X amount of dollars if he gets 20 touchdowns in a season. Why don't we allow that? Or why doesn't the NCAA allow that for college athletes? And similarly, I think it makes it difficult for brands because brands can't necessarily escape contractual obligations by putting in clauses where they don't have to necessarily pay the athletes if the athletes aren't performing. So it works both ways. And I don't really understand the justification behind it.
Well, I mean, I think one of the questions is if you look at what the general counsel of the National Labor Relations Board, Ms. Abruzzo, said, and they filed a case in the Northern District here in California, and they're saying that they're employees. Now, once you call those formerly student athletes employees, you're opening up a gnarly can of worms, as it were, because first of all, what does that mean? Well, I can organize. That's one issue. The athletes could organize, fine. The other issue is, well, if one of the terms of my employment is that I have to complete 12 units per semester to maintain my employment, that's a condition of employment, fine. But now the value of that scholarship becomes a taxable event. So am I net going to make more money on NIL than I would otherwise? I mean, you got 53 scholarship athletes or whatever the number is in football, for example. If those guys are deemed employees and they're getting paid, you know, it might be costing people to go to college. I think that, you know, the slope is so slippery. I don't even know what the answer is, but I think asking these questions is critically important, largely in part because I would venture to say a significant number of scholarship athletes in the big three sports don't have, or their family doesn't have, the financial sophistication or the education to deal with these kinds of issues. And that's a real problem. I mean, there has to be some sort of welfare considerations, big picture, for these kids. And that becomes a concern, I think.
From my perspective, I think it's quite clear that when we're talking about football players and basketball players at the D1 level at a minimum, these individuals should be classified as employees. I think there's the requisite amount of control by the universities and the athletic departments to characterize them as such. But interestingly, I also think that for perhaps the majority of athletes that could be classified as employees and may be vocal about wanting to be classified as employees, they should be somewhat careful of what they wish for. I do believe that there are many benefits from being classified as an employee, having being a W-2, having a salary, and in particular, as you mentioned, having the capacity to organize as a union. I mean, nothing prevents athletes right now from organizing as a trade association, but that doesn't have the same strength. But I think the biggest benefit from classification as an athlete and unionization is probably the negotiations surrounding the health, safety, welfare portion of the component for the athletes, where I hear a lot of disdain or disgust from athletes about just how many hours they have to put in that it takes away from their studies, that it's dangerous in many occasions based on the conditions of the workplace. Now, there's also some who believe that they'll make a lot more money, and maybe that's true for some, like the Tim Tebows of the world. But for others who are maybe fringe players and don't have the benefit of a stable scholarship, what if they're in a state that's at will and their employment can be terminated at any point in time, and they don't have that safety net that they currently have under the status quo? So I think going through this process, if we get there, it will serve to be an extreme advantage for some, an advantage probably for all from a health, safety, welfare standpoint, but also a disadvantage for many from an economic standpoint and also from a stability standpoint. And I think it'll be very interesting to see what happens, because right now we have this vacuum of money that's been built up from boosters and through collectives, money that maybe otherwise would have gone traditionally to the athletic departments for building new facilities, paying the coaches, et cetera, although none of them are hurting despite what they may say, maybe some, but the vast majority are not. How will that translate if and when athletes become employees? I think that's something that's going to be very interesting to follow.
Well, I think the bigger issue is the, massive flood of conference realignment we've seen in the last couple of years, particularly with public universities, that because states have withdrawn so much traditional funding, a lot of these public institutions have relied on money from the athletic department, particularly from the big three sports. And that money comes from media rights. And now you've seen with the implosion of my beloved Pac-12 conference, I'm really a Pac-8 guy, but I'll deal with the 10 and 12. And those schools left because they needed the money and they weren't getting it from their media deals. So 100-year-old conference seems to die, notwithstanding what Oregon State and Washington State want to say.
Yeah.
And there's a lot of changes there, and this all has to do with money. And I think for years, it's been clear that you've heard student athletes saying, University of Texas made $127 million last year, and I'm getting a scholarship and nothing else. I'm not getting a piece. So I'm not sure if this is a pendulum now that swung one way and we'll come back to some point of stasis. Who knows? It's just an incredible time in the college space. And when I look at one of my favorite examples is the Cavender twins. Okay.
Yeah.
They should never leave college. They'll never make that much money in the WNBA. I mean, they're probably going to make a couple $1 million this year.
So
and the highest anyone in the, the highest salary in the WNBA, I think, is like 700,000, which is if you make the playoffs and get to the championship, et cetera, et cetera, et cetera. So maybe the whole world of NIL prevents one and dones. Maybe it keeps kids in school longer because they're making more money. I think maybe in female athletes, it finally gives them an opportunity to make some money. But, there's so many sea changes just in that area.
Well, it absolutely does keep many athletes in school longer than if NIL wasn't in place. I think more so the Caitlin Clarks, and the Angel Reeses of the world, who are very talented both on and off the court and have the capacity to enter the WNBA right now and excel. There's a big reason why you don't see them and other talented names leaving, because they're making so much money and they may not even have the same marketability, interestingly, when they go pro as they do currently. With the Cavender twins, they actually did leave school, but interestingly for them, they've built up such a large following that they're doing just as well, if not better, now that they've left school. They're not going to the WNBA, but they've turn into something larger than being athlete influencers. Um,
They became
Interestingly,
they became a brand.
they became a brand. That's absolutely correct. And so we see it with many football players, even who get draft grades that are, let's say, between the third and seventh round. Many of them will stay if they're marketable because they realize that they have the capacity to not only continue to make NIL money, and oftentimes collectives will pay them to stay, even though they're not supposed to be doing so, but also go through and complete their educations and stay in that amazing college atmosphere that we all miss.
Yeah.
And try to get a better scouting profile for the next level. So I think there's a lot of inherent benefits that run alongside of the fact that many athletes are staying. Look, if you have a first round grade or you're supposed to be drafted number 1 overall, you're an Anthony Richardson from the University of Florida who goes top 10 and becomes a starter for the Colts, you're leaving, despite the fact that you made hundreds of thousands of dollars in school. But
Well, yeah,
many,
I mean, if you're a first round guy, you look at what the money is, and you go like, well, I could stay in school, which is great, and work towards my degree and make $300,000, or I can go to the NFL and get a $22 million guaranteed bonus. Yeah, you're not staying in school.
Exactly.
Well, look, Darren, I appreciate you taking the time out of your day to talk with us. This was maybe a 40,000 foot view of what's going on, but it's just a huge growth area for us sports lawyers. It's an area that I think we all are going to look at more and more. We'll see, what happens with NCAA guidelines, since they don't have really any enforcement anymore. And we'll see if Congress acts, but if they can't deal with copyright law, I don't think they're going to get to NIL law. So it's an interesting area. I think there's a lot of news. I'll point people to your regular NIL site, which is they can read that at.
It's on LinkedIn. It's called Newsletter Image Likeness.
Yeah, and it comes out every week, and it's got like, I don't know how you have the time to even work and put that together, but it's a really good compendium of what's going on in the space. So again, thank you for taking the time. And for those of you out there that are watching this that are not yet members of the Sports Lawyers Association, please go to sportslaw.org and become a member. November 2nd, we have our second mid-year symposium on AI.